Okay, well, welcome to drum roll, Defamation Day. One of my favorite days because we get to creep and spy and talk trash about people. But before we get started, I wanted to take a few minutes and talk about the case brief practice that you guys did on Blackboard last week. So if you want to pull up your responses to that, that would be great. Because next week, part of your homework is going to be to write a bigger actual brief on one of those cases that you selected. So I want to make sure that we understand what we did right and what we did wrong, so that next week everyone can write amazing case briefs and not lose any points on any of the small stuff. So what we're going to do is talk about case brief from last week first and things to keep in mind for next week. Then we're going to look at defamation, and we're going to start off by trying to identify why do we even have these rules? Like, what are the fundamental principles governing this phenomena in our society? Then we're going to look at the elements and the difference between slander and libel, and you'll find there's a couple of confusing gray areas. What are the defenses? Since a lot of you are going into journalism, advertising, PR, anything in the communication world, if you or your firm are sued for defamation, what are your defenses? What can you say in the court to protect yourself? And then we're going to talk about some examples and then wrap up by going through the homework. Sound good? So nice, easy day. All right, so most of you came to the correct solution when we looked at Nix versus Hedon, that amazing 1893 Supreme Court case. Are tomatoes fruits or vegetables according to the United States Supreme Court? Well, it was an either or. Are they fruits or vegetables? The comment from the audience is no. All right, Jake.
The verdict that we got was it didn't matter if they were technically fruits or vegetables, the actual vegetables.
Okay, so the short answer is vegetable. Okay, and we can talk about the analysis that you just kind of went through, because that was the court's analysis. So when you're writing a case brief, one of the things I want to point out very clear for you all moving forward into next week is it's not an essay. You're not writing an essay. So for this practice one, a paragraph is fine. But what I want you to do moving forward is to make sure you have the categories clearly marked, like bold or underline or italicized. And so let's go through this case and let's go through the different categories. So when you're writing a case brief, the first category is what? What do you need to have? The title, or you could even call it like the site or the parties, however you want to label it, right? The site, parties, title. So in that, our title would obviously be Nix versus Hedon, but you're also going to need to put the location of where you can find the case. And so that's not a website. It shouldn't be www.fruitsorvegetables.com. It's going to be a number plus some letters. So in this, it is, where is it on here? It's 137. Isn't it 137? What did I put on Blackboard? If you go into my instructions on Blackboard, I said find this case. 130, is it 137?
149.
Oh, just kidding. 149. US 304, and then you can put the year, 1893. So for those of you that think you might go into law, or if you ever think you're going to be writing and using cases in your papers, you want to have the proper citation. So this is going to be that citation. Back in the old days, we didn't have things digitally. All Supreme Court opinions went into books called reporters. So when I went to law school, even though we had internet databases of cases, we were taught how to find the actual book, and the librarians made us hold a book in our hands. It was like super dorky. She was like, pass this book around, right? Because then everything else was all online. This is the same equivalent to finding book 149 of the United States Supreme Court reporters of all of the cases, all of the opinions it's decided. And then this is the page number where the case starts in the book, in the reporter. So if you're ever writing a paper for another class, now that you have a kind of an understanding on how to do legal research, if you want to cite a case, and if you pull a quote from a case, you want to have the reporter number, this is the court, and then this is the page number. And if you have a quote, then you'll do a comma and then write the page number where the quote is. All right, so that's kind of how you do it in a nutshell. You can take this piece here, and then obviously the year was decided. You can take this piece here, put it into Google, the case will show up. You put it into Westlaw, the case will show up. If we ever go through a phase where internet crashes forever, we at least have printed books in libraries where you can go and pull volume 149 and flip to page 3 or 4 to find it. All right, so I need you to put that information in that top part. And if you want to go so far as to explain who the people are, that's fine too in that category, because sometimes it's confusing. So who is Nix in this case? He's the plaintiff. Okay, what did he do? What was his occupation? He was not a farmer, but he liked to, yeah, he didn't grow the produce, but he imported the produce. Does anyone remember off the top of your head where he got the tomatoes? Yeah, the West Indies, okay, wherever that geographically is, the islands in the Caribbean, right? Yeah. Okay, so you have someone in New York who imports produce and then turns around and sells it at markets, grocery stores, whatever type of shops existed in 1893. Who is he? The collector of the taxes, right? Anytime that you import some type of product from another country, there's going to be an import tax. So this guy was like the port, the tax collector of New York. So that's who those parties are. The facts of the case are what? Not what happened in the court system, but what happened to cause this issue to enter into the legal system. How would you summarize what happened? Why was Nix pissed off? Gabrielle, if you want to weigh in, you can type your answers into the chat as well. You guys just did this last week. Why do you think he was mad? If he imported produce and someone's charging taxes, what's he mad about? The taxes. He was charged under a new tariff about importing vegetables. And so he sued the tax collector, saying, I paid all this taxes that I shouldn't have because I think tomatoes are fruit. So I want my money back. Does that make sense? He paid all these taxes, but then under this new tariff act, he realized that only applies to vegetables. Well, tomatoes are fruit. Those are the facts of the case. The facts happen before it enters the legal system. Make sense? The next category is procedural history. That's once the case enters the court system, how did it make its way from the trial court all the way up to the United States Supreme Court? I mean, can you even begin to imagine, like, why are tomatoes fruits or vegetables? Why that even made it all the way up to the Supreme Court? Like, why do you think that's so important? Like, what happened to this case? So it went to trial, and then what happened to trial? What type of evidence did they hear about at trial? Dictionary definition, because apparently people back in 1893 had no idea whether tomatoes were fruits or vegetables. So you say at the trial court, they read the dictionary definitions, and then how did the court rule? What did the lower court say? Is it a fruit or a vegetable? The trial court. Give a 50-50 shot. Anyone guess? They said it was fruit. Anyone? Opposite. Matt, say the opposite. Vegetable. Way to go, Matt. Congratulations. So sorry, Jake. Okay. So the trial court said Just kidding. It is a vegetable, which means who won at the trial level? The produce guy or the tax collector? The tax collector won. Because remember, he wanted them to be vegetables because he didn't want to have to pay money back to that guy. So who's pissed off? The plaintiff, right? Because he just lost. So he appeals, and it makes its way to the Supreme Court. That's what you would put in this section. What happened at the trial, and how did it get up there? Yeah. So there was a motion filed by the defendant, by the tax collector, and he asked for a directed verdict, which means the court kind of skips ahead and just enters an opinion, enters the verdict. And it was, right, it was entered when he asked for that. But the plaintiffs then, right, the produce person said there was an error and filed an error. So when it went up to the Supreme Court, at the very end it says judgment affirmed. It said it agreed with that trial court's decision that there was no error. Okay, and that's a good question, Latifa, is that the error part. When you get to your case that you're going to work on over the weekend, you're going to find language that you're like, wait, what does that mean? And that's totally okay. And you can absolutely reach out to me for help, or you can look at secondary sources like Wikipedia or Google it and see what you can find. What is the issue or the question that the Supreme Court had to decide? I think most people got this right on their little case briefs, but what did you guys put? Haley, what's the question here? Yeah.
Oh,
Caleb, I'm sorry, Caleb. What's the question the court's deciding? Are tomatoes vegetables or fruits? Right? So that is the whole point of this case. So that's the issue. Then you can talk about how does the court reach its final verdict. So that's called the analysis. And the holding is the final result. So I've already said what the ruling of the Supreme Court was, and that is that tomatoes are vegetables. So the holding is tomatoes are vegetables, and it affirmed, gave a big thumbs up to that trial court's decision. It said you did it right. So for the analysis, this is going to be your longest section, because you're going to talk about how did the court make this final decision. So you can bullet point, you can type out the rules, or you can just say, the court looked at all of the evidence presented at the trial. So they looked at definitions, but then they did more than just look at definitions. I think as Jake or Matt, I forget who, pointed out that they looked at how do people use tomatoes. They looked at the ordinary use of a tomato. And in fact, some really beautiful language, if you think about it, where it talks about they're eaten cooked or raw, just like potatoes. They're served at dinner with soup. They're made into soup. They're a principal part of dinner, the dish, etc. Because how often do you eat a soup that has fruit in it? Or how often is your dinner made of fruit? Right? Tomatoes are definitely more of a vegetable because you use it in that everyday context. So you would walk through all of that analysis. Okay? And then that is what made the court decide that they are in fact vegetables. So this is one of those amazing pieces of trivia when you go home to think at Thanksgiving and you're sitting around the dining room table. Your parents say, well, what have you learned this semester in college? And you're like, well, I haven't learned anything. I mean, I've learned one really important thing, Mom, that the Supreme Court of the United States thinks that tomatoes are vegetables. Mic drop. Just kidding. It's not that impressive of a trivia, but I think it's kind of fun. Okay, so when you are doing your case briefs for next week, do not write it in essay form. You need to label the different parts of the case brief and then write sentences next to it. But this is not like a research paper or the essay that you guys just did. Also, several of you cited outside secondary sources. Someone cited Wikipedia, someone cited something else, like a website they had pulled from. And while it's okay for you to consult outside sources to help you understand the case, make sure what you're putting in here is information that you got just from this document. Because in real life, if you were doing this to get ready to go to court or to write a memo, or if you're in law school, they're going to want to know what the court said. That's more important than what Wikipedia said. And then the only other thing that I would have to say is all of this needs to be put into your own words. Why? If you just cut and paste, what will Turnitin do? If you just cut and paste language from your case and put it into this assignment, Turnitin is going to go, plagiarize, right? And the whole thing's going to light up red. So if you're going to pull things from the case, make sure you use quote marks and put the citation next to it. Otherwise, just put it into your own words and paraphrase it. Make sense? So those are my 3 tips. Not essay, read outside sources, but make sure you don't reference them in this document, and then put it in your own words. Because just like what we did last week with our essay discussion in class, all we're doing next week is talking about these cases. So again, you need to be prepared to explain the case and all of the parts of the case brief to the class. If that feels overwhelming to you, go to the Center for Public Speaking and practice. Just say, we're doing a class discussion. I need to rehearse my piece, and I'll throw some extra credit at you. Because something tells me our midterms are around the corner, and you should probably start gathering some extra credit points where you can. All right? So you need to have written this before you come to class, because we're going to be talking about them. That's all we're talking about in class that night. Got it? Good? Good? Okay. Sweet. I think most of you guys did a really good job. I couldn't tell if you just copied and pasted from Wikipedia, though, because it was just a Blackboard discussion post and it wasn't Turnitin. So just be very careful about the Turnitin monster, because it will definitely come after you. All right, I want to start by playing a little video clip. I'm going to do a share screen. Oh. Okay. Gabriella, can you see the YouTube?
Yes.
Okay, good. Never know with technology. Did all of you look for and find an example of something that could rise to the level of defamation? Remember me saying that? If not, while this is playing, you can do a little Googling. Not necessarily like defamation, but see if you can find a tabloid, a headline, something that someone tweeted, posted, or something that you think might rise to the level of defamation. But we're going to watch this short little news clip about a defamation case involving Jesse Ventura. Who is Jesse Ventura, y'all? He's a wrestler. So he is an actor? Okay. Isn't he the governor of like Minnesota or something too? So kind of like Arnold Schwarzenegger becomes the governor of California. Jesse Ventura was in Predator? Wow, classic movie. Okay, well, Jesse Ventura sued an author who you will recognize, even though you might not have read the book, from the movie American Sniper. You guys watched that movie about the guy in the military that was the sniper? Okay, so let's see what happened with this defamation suit.
Courtroom victory this morning, but some critics say the fight over best-selling book hurt the deceased author and his family. We'll talk to the former governor in just a moment. A Minnesota jury decided Tuesday that a fellow Navy SEAL veteran damaged Ventura's reputation.
Chris Kyle was regarded as the deadliest military sniper in U.S. history. He wrote in his best-selling 2012 book that he punched out a celebrity inside a California bar back in 2006. Kyle's book, American Sniper, called the man strut-faced. said the man took a swing at him, and after that, Gruffface ended up on the floor. But in promotional interviews, Chris Kyle identified the man he slugged as Jesse Ventura. Ventura was in town for a Navy graduation, but says the incident never happened. In 2012, shortly after the book was published, the pro-wrestling former governor of Minnesota filed a defamation lawsuit against the author. Kyle was shot and killed by a fellow veteran in a Texas gun range in 2013, but the high-profile lawsuit continued. In videotape testimony taken before his death, Kyle said his story was accurate. The federal jury deliberated for 6 days, and on Tuesday awarded Ventura close to $2 million. His attorney said the case was about Ventura's reputation.
It is a victory in a sense that the jury did tell the world Chris Kyle's story is a lie and it was a fabrication.
Okay. Apologize for the bad sound quality. I think it's because of the zooming that's happening. All right. So did everyone understand that? Chris Kyle, the star character of American Sniper, he was shot and killed on a gun range. I think you guys might remember that from watching the movie. But before he passed away, he wrote a book, and in the book, he generically referred to a fellow Navy SEAL as Scruff Face, and said they got into a bar fight. And from that, it sounds like he described it as the guy like swung but missed, and then Scruff Face landed on the floor. So Jesse Ventura got mad and said that he was talking about him in the book. Sued Chris Kyle for defamation. Chris Kyle passes away, right? He's murdered. So his estate, the entity that's now controlling like all of his assets and stuff like that, is named, right? It goes to them. And the jury awards Jesse Ventura $1.8 million. All because written in one book is some reference to someone named Scruffface that basically looked like an idiot in a bar fight. So my question to you is, do you think that's worth $1.8 million? That's pretty wild, right? That's pretty wild. So what we're going to start off by talking about is, why do we have defamation laws? If you remember back to our first in-person class day, we spent all this time talking about the First Amendment and how we have so much freedom to express ourselves. But we constantly keep coming back to this idea that you can't just say and do anything, right? So why do we care about defamation? As a society, why does this exist? Anyone? Yeah. Okay, so if you have a high-profile person, we're concerned with damaging their reputation. And the way that we hurt someone's reputation is by saying or printing something that might lead to some type of hatred from the general population, ridicule. They might be scorned by society, or society might have contempt for them, which is very similar to hatred. So which one of these feelings or outcomes do you think Jesse Ventura would point to? What was he scared of? Was he scared of being hated by society? Was it contempt, ridicule? Jake?
Probably scorn. Never a good look, like in a fight with a former veteran.
So one reason Jake says scorn, part of that could be Navy SEALs are a pretty close-knit group. And so if you have someone and you're talking about them like being weak in a bar fight, it's possible in Jesse Ventura's mind that he'd be scorned by that population. He also is probably scared of what? I mean, he lost a bar fight. Ridicule. He looks like a dumbass. Like he doesn't know how to fight. Right? And he's referred to as scruffy, like whatever that means. Okay? So these are some of the things that people worry about, but not just rich or famous or celebrities. Even just the average person can sue for defamation. So there's 4 things that I want to point out that I want you guys to take some notes on. This chapter in the textbook was a lot, I know. So I want to try to distill it down into some key takeaways for you. So first, we start with this general principle that people have the right to protect their reputation. Anybody, not just public figures, not just celebrities, wealthy individuals, etc. Pretty much anyone. This will damage their standing in a community. So back before the internet, before TV, when we lived in smaller communities or villages or something like that, people really had to rely on each other. So imagine we're back in England, 1600s, and we're in a small village. We need to know that the blacksmith is, reputable. We need to know that the doctor is reputable. So it's that principle of standing in the community. Something's defamatory if it lowers a person's reputation before other people. And that defamation can cause these different things. But what we look for in a modern day definition or understanding of why we have defamation laws is that it interferes with someone's existing relationship. So let's take, for example, I went to Miguelitos last year, and I had terrible service. I went for bottomless mimosas, and I got maybe 2 because the waitress never came around, the food came out and it was cold, etc. I did leave a nasty Yelp review, but we'll talk about Yelp reviews and that type of stuff towards the end of class. But what if I made it my mission to put Miguelitos out of business? I mean, you pay $20 for bottomless mimosas. I expect at least 20 mimosas. Okay, so it's my personal campaign against Miguelitos. I think their food's terrible anyway. I create an ad. Oh, I know that's big statements, right? Big statements. You don't work there, do you? Okay. Kayla's eyes got real big. You love it? Maybe it's changed. Maybe they fired that. Okay. All right. So I take out an ad in the Tampa Bay Times being like, "Fuck Miguelitos," right? Their bottomless is not bottomless. Their food is cold. Blah, blah, blah. And Miguelitos, okay, starts to lose business. How is my ad interfering with their existing relationship? Who does Miguelitos have a relationship with? Yeah, Sam. Customers. They might have a reputation in relationships with other restaurants, right? There's probably local restaurant associations. And maybe even the suppliers, right? The people that give them produce and sell their products. So say they don't make that salsa in-house, they use Mamacita's salsa brand. And so now that Miguelitos is in the toilet, Mamacita's salsa takes a hit as well, okay? Because that was their biggest client. So existing relationships. Defamation also interferes with a plaintiff's future relationships. So maybe it doesn't damage their reputation with other restaurant companies, but people will stop going there once they see my ad. New customers might not go because I've damaged their future relationship. Next, defamation destroys a favorable public image. Kayla really likes Miguelitos. And let's say Miguelitos has a really big fan base. People, go there every Sunday brunch, right? They really, really like it. But I've now damaged or I've destroyed that public image. They really prided themselves on being a modern Mexican restaurant, to attract young crowds, and serve the all of a sudden my ad has like ripped that down. But can there be defamation against someone that's not a public figure? Absolutely. So the alternative to that is, here they already have a good public image. But if there is no image at all out in the public, what it does is it creates a negative public image. So you've got those two prongs, right? It can destroy someone's existing reputation, or it can give them a bad reputation where they haven't had a reputation yet. Does that make sense? So you look to the current impact on existing relationships, what might happen in the future, like future loss of business in this instance, and it can destroy a good reputation, or it can create a bad reputation. So those are 4 really strong justifications of why we have these laws in place that restrict our ability to express our opinion and to speak. Make sense? Okay. So let's talk for a minute about the elements. What do you have to prove in order for there to be defamation? Does everyone get all of this? Erase. Trying to write within a certain frame for the viewers at home. All right, you guys are supposed to have read the chapter before coming to class today. What is one requirement for there to be defamation? Yeah. There has to be, you're going to laugh, there has to actually be defamation itself. There has to be a false what? Yeah. Claim or statement. And what type of statement or claim does it have to be? It has to sound like what? Because I could say Miguelitos is a massive diarrhea factory. Am I really making some kind of factual statement here, or is that more of an opinion? It might be more of an opinion. So there has to be a false claim or statement that sounds like a fact. It has to sound like a fact. So there is some message, whether it's written or spoken or through a cartoon or a billboard, that is an untrue statement that is factual in nature. Because opinions are not necessarily defamation. In certain categories, sometimes opinions can rise to the level of defamation. It has to be a factual statement. Now, how do you determine if this is something that like causes harm? Because that's the other thing that has to harm. So it's a false factual statement that causes some type of harm. So how do we know something causes harm? Yes. If it affects future earnings, so that's one thing. You can do a financial analysis. If it's a business person, or if it's a business or a company, and they lose money because of that statement, okay? But what if there isn't like a dollar sign we can point to yet? Who decides whether something's hurtful or not? What do you think? Who do you think the courts would look to decide? You guys heard of the reasonable person? In the law, there is this concept called like the reasonable person standard. So they're going to look at right-minded, right-thinking people, like in the community. Would the average rational person hear a statement like this and say, yes, that is going to be hurtful. Because otherwise, I might say something and it's going to be extremely hurtful to Matt, but Jake doesn't perceive it as hurtful. So can Matt sue me for defamation just because it hurts his feelings? Right? If there's no money to show, the courts are going to ask like a rational person. They use like a reasonable person standard. So again, would right-thinking people hear this statement, read the statement, view the statement, and think that it does cause some type of harm? Because not every time there's money attached to it. Although that makes defamation a lot easier when there is money attached to it. So what happens? We've got this statement, or I take out an ad about Miguelitos. I design this ad with a volcano shooting like diarrhea, big claims about like they're not bottomless mimosas, it's a scam, it's a lie. Okay? But I just take that ad and I frame it and put it in my kitchen. Is that defamation? What's the difference between me framing that ad and putting it in my kitchen or putting it in a newspaper? What's the difference there? It has to be public. That's right. It has to be published. So in this example, with the ad, I'm publishing it in a newspaper. But not all defamation has to go into a newspaper or a magazine or a flyer, because there's spoken defamation as well, right? What do we call that? Slander or libel? 50-50 shot. Slander. Slander is the spoken defamation, and you'll know the difference by the end of class. So how do we publish slander or spoken defamation? How do we publish it? Yeah?
Through video.
Video is one way, but think back, these rules existed before video technology. You just have to say it, right? Publication basically means you are transmitting this information to a third party. Whether it be video, billboard, ad, me just simply telling you something that's false in the classroom. So again, if you think back to day one when we talked about the communication model, this person could be saying defamatory remarks, but if no one hears it and no one's on the other side, does defamation actually occur? No, it has to be received by someone, a third party. So let me give you another example. Dr. Gurry in the speech program knows that I use him as examples for defamation in all my classes, so I feel pretty safe about putting this in the lecture video that's going to be on YouTube. But I might say, Dr. Gurry steals UT laptops. He's always asking, saying he's broke down, and then he steals UT laptops. He steals company property. If I say that statement in an empty classroom, is there defamation? I storm in before class starts and I shut the door and I yell, he steals company property, he's a thief, he should be fired. But no one hears it. No one hears it, right? That person doesn't exist. No defamation. Got it? So publication means it's communicated to a third party. Got it? Good? Okay. Because on your drive home, feel free to defame me all you want. You know, if you're in your car and you're like, fuck Folds, fuck that class, she's a terrible professor, blah, blah, blah. That's fine. That's not defamation because there's no audience. No one's heard it. You have to make sure it gets out there. Because otherwise, there's no harm, right? If it's something like that you say in the privacy of your own home, there's no defamation. All right, last thing. What do you think the statement has to do or say? We know it's a false statement. It causes harm. Other people hear it. But what does it need to specifically do? What information does that statement have to contain? Yes, Jake?
Negative.
Well, it's going to be false information, so I would say that's negative, okay? But what else does it have to do? If I come in here and I say someone is stealing UT's property, is that defamation? It's not. Why? What piece of information is missing? Not the subject, it needs a person. It needs a name. Yep, exactly. It has to identify. It has to identify a person. And that person in a lawsuit will be the plaintiff. It has to identify the plaintiff because they're the injured party. So the person making the defamatory remarks are the defendant. And the person that it's about, right, the content of it is going to be the plaintiff if we're talking about a person in the defamation. So let's analyze Jesse Ventura's case. Is there, well, we know the jury said there was defamation, but let's break it down. What is the false statement of fact that causes harm? The false statement of fact is he got beat up at a bar. It sounds like he fought like a pussy, right? He got beat up at a bar. Jesse Ventura has to prove when he goes to court against Chris Kyle and Chris Kyle's estate, he's going to have to prove that that statement is false, that he was not beat up at a bar, that it is a factual statement and not an opinion or fluff, that it sounds like a factual statement. And he also has to show that he was harmed somehow. So that's going to be difficult, and we'll talk about that towards the end, is how do you prove that harm? He's going to have to go through and pick up, like, how do you prove damage to someone's reputation, right? You don't get money awarded to you in court just because my feelings were hurt, right? You have to actually prove some type of damage. So maybe, you know, he applied for a job and he didn't get it, or he lost money on, you know, public speaking gigs, or the Navy SEALs shunned him completely. He's going to have to prove some type of harm. How was that statement published? In a book, and it was received by all of the readers. Because if it was published in a book that was never passed out, there might not be defamation because no one read it. But here's the kicker. Does it identify him? According to that video, how was he referred to? The man with the scruff face. So, to identify someone in the statement, you don't have to necessarily have their name, but there has to be enough information that, again, that reasonable person will know who you're talking about. So, getting back to Dr. Gurry, if I say a member of the speech department who has a beard, who's this tall, is stealing UT property, you would be able to figure out who I'm talking about. Because we only have one professor with a beard, and there's only one professor that's this tall, that's a male. Okay, so again, they didn't have to say Jesse Ventura by name in the book, but a reader should be able to figure out who they're talking about. Got it? Make sense? Okay, so my question for you, because I wanted you to try and find an example of something that you think might be defamatory, is pull it up on your computer. And if you forgot about it, that's fine. I don't know if it was in the syllabus or not to have an example, but can I have one volunteer of like just an outrageous story that you might have found? Yeah.
I found a case, Gibson's Bakery versus Oberlin College, June 2019, Ohio Court of Common Pleas.
Okay, so this is a bakery incident with the university.
Yeah.
Okay, what happened, Jake, in this?
A libel claim by a local bakery against the college and the dean of students alleged that the business practiced racial profiling, and then it was discovered that it was not true.
Okay, wait, just for the recording. So the college, Oberlin College, and the dean of students said or put out a statement that this bakery was racist. Okay, pause there. Could this rise to the level of defamation? If it's false, yes. Does it sound like a factual statement? It is racist. Is that a factual statement? Yes. Do you think it caused harm? What harm to the bakery would it have caused? Yeah, it would have been reputational damage that probably would have seen a drop in their revenue. And so you can really pinpoint when it's defamation against a business, you can pinpoint that. How was it published?
I'm not entirely sure.
Okay, but let's say maybe they put it in the school newspaper, or maybe the school sent an email, or maybe just they were having a rally about diversity and someone said, yeah, don't go to this bakery, it's racist. It was published if other people heard it. And did it identify the bakery in that statement? If it had just said, hey guys, that bakery around the corner is racist, do you think that's enough information to identify what business is racist? Probably. Now, what if there were like, what if it was like Bakery Row and there's like 6 bakeries in a row down the street? Then you might have a little bit of more of a discussion of, did it identify that bakery exactly? But if that statement was clear cut enough, right, I'd say yes, it identified. So Jake, what happened in that case? What was the result?
Oh, I found out how it was published too. if you want that.
Yeah, how was it published?
There were a bunch of protests on campus and the school like supported.
Okay, so there were protests. So students found out. It'd be kind of like, do you remember Tampe's, that pizza place around the corner? Now it's something like a European restaurant next to Oxford Exchange. If they found out that the people that own that restaurant were racist, and then students have like a rally and people have like posters saying boycott that restaurant or something like that. Okay, good. Thank you, Jake, for sharing. So I want to pick up another example to walk through these elements, and then we're going to do this. I'm going to ask you as we go through the rest of the material to find your example. So one other example. Yep, Sam. It doesn't have to be a case. It could have just been a tabloid headline.
Yeah, that's what I found. I saw like the Daily Mail Australia posted like the headline was like anything to tell us, Sylvia Jackson pregnancy.
Who is Sylvia?
She's married to like
Okay, so you have the Daily Mail in Australia, which is interesting. I thought it was just Daily Mail UK, but Daily Mail Australia fuels rumors that a star is pregnant.
so that she's pregnant.
That she's pregnant. Okay, so does that is it a false statement? So she's not pregnant.
Because then like she like reports back that no, she's not pregnant.
Okay, so the stress I feel like makes me look pregnant. So something about like the cinching here. That's your cue to say, no, Professor Fultz, you do not look pregnant in that dress, but you guys are all failing miserably, and I'm going to remember this when I'm grading your final papers. They publish a picture of me like this, right, and I'm a celebrity, right, kind of hinting that they're pregnant, right? False statement of material fact that would cause harm, because what harm could happen to this actress or this person? Body image, or what would happen if maybe is she an actress?
I think she's a journalist.
She's a journalist. Okay, well, let's say if she is a journalist and she's applying for jobs and people look and they see like she's pregnant, what happen to her job chances? You're not supposed to discriminate against people based on like pregnancy stuff, but why would a newspaper hire someone that they know immediately is going to turn around on maternity leave? Or if she's an actress and it comes out she's pregnant, what might happen to that actress's jobs? Like, what if she has a contract to be in a Marvel movie as a superhero, and then they find out she's preggers? She can't put on that bodysuit when she's pregnant, right? Or how many thousands of dollars would it cost for them to like Photoshop out the baby bump, that kind of thing. So there could be some type of harm by insinuating someone's pregnant, right? Published because it was put in the Daily Mail, it was viewed by readers, and it clearly identifies the plaintiff, the potential plaintiff, because it's actually her photo. So good. So could be defamation. The Daily Mail, incidentally, published that Melania Trump worked as an escort before she married Donald Trump. Do you think that rises to the level of defamation? It certainly identified Melania Trump as a prostitute. It was published because it was in the Daily Mail newspaper that got circulated. It is a false statement that sounds factual that probably caused her harm. Because if that statement was left like out there unchallenged, when she's no longer first lady, what if she wants to go back to modeling and she doesn't get any job offers because they think she's a hooker? So with that, she filed a lawsuit against the Daily Mail, but ultimately settled out of court. So the Daily Mail just paid her off so that they didn't have to go through a very public trial. Does that make sense? All right, cool. Now, let's throw a little wrinkle in this. From your reading, do we, the answer is yes or no, 50-50 chance of a correct answer. Do we treat celebrities and famous people or famous figures the same when it comes to defamation, proving defamation, as we would a normal average person? Are celebrities and public figures treated the exact same about defamation? You're shaking your head, no? Why not? What's different about them and, I would say, us?
People also have a they're like different. So like it's not just them about it, it's about the
Okay. So celebrities have like a whole team, so maybe that justifies having a different standard, okay? What else? What else do celebrities do? They intentionally put their lives out on blast, right? They live a life in the movies. They kind of give up a little bit of that personal privacy because they've chosen to live out there. Now, you were right. We do not treat celebrities and public figures the same way as we would the average bear. So the average person, when we say we're defamed, we, as plaintiffs, have to prove all of this stuff. We have to prove that it's a false statement. We have to prove that it harmed us. Celebrities have an extra burden that they have to prove. Does anyone remember what it is from the reading? The little nugget, a little gem buried in the chapter. Yes. Malice. Not just malice, actual malice. We get this concept from a Supreme Court case, and the year that it was released does not ring a bell off the top of my head. New York Times versus Sullivan. This is a very important case that I want you to make sure you write down in your notes, because I will most likely test you on it, because it is a very, very important Supreme Court case. Sam, do you remember what happened in that case, if you remember malice? Vaguely?
Not really.
Okay, New York Times versus Sullivan. So Sullivan, just like Sullivan. I think there's one way to spell Sullivan. All right, so you know it's a defamation case. It's actually a libel case because it involved a newspaper. This was sometime around like the civil rights movement. Again, I don't remember the exact year, but Matt, do a quick Google, New York Times versus Sullivan, and pull the year. 1964. Okay, so right in the heart of civil rights era. There was a newspaper ad that basically said some negative things about a public official. And public officials in, wait for it, Montgomery, Alabama, of course, right? Alabama, hotbed of like every civil rights violation and like the source of a lot of civil rights movements. One of the, let's see, the commissioner of public affairs in Montgomery, Alabama, turned around and sued the New York Times. Okay, so Sullivan was the public official down in Montgomery, Alabama, said that ad is an attack on me. The trial court in Alabama awarded him $500,000. So In 1964, how much money do you think that would be? $500,000 in 1964. What would the modern day equivalent be? Probably a hell of a lot of money, right? Like millions and millions of dollars. So what do you think the New York Times did? Are they going to just like pay up all this money back in 1964? That's a lot of money. What do you think they did? What can you do if you're unhappy with a court's decision? You can appeal it. So they appealed it, and they got to the Alabama Supreme Court, and the Alabama Supreme Court said, no, you still owe him $500,000. So they sided with the plaintiff. So what do you think the New York Times did then? They're still unhappy about having to pay all that money. They took it and appealed it up to the U.S. Supreme Court. So that's the procedural history of that case. New York Times lost at the trial level to the tune of $500,000. They appealed it. The Alabama Supreme Court affirmed and agreed with that $500,000 verdict. Again, unhappy, appealed it up to the United States Supreme Court. You think the United States Supreme Court was like, yeah, you still got to pay this guy? Or did they look at the fact that he was a public figure, basically a government official, and decided maybe we should treat them a little different? Because similar to when we talked about the theories of free speech, remember how we talked about like the self-government model? One of our rights, we did talk about that in this class, right? Like why freedom of speech is important. Freedom of speech is important for us to challenge what our elected leaders are doing and what they're saying. If we elect someone to hold a public office, whether it's local, state, federal, and they fuck up on the job, we are allowed to challenge that. Maybe not Kenya, probably. But here, we're absolutely allowed to criticize and challenge our elected leaders. I always think about what you said about the journalists and stuff like that. So. You don't hear about it on like.
Yeah, but it's better now than it was before. Like presidents, so the only thing we talk about is what the president was doing. It was only like positive. Like
it was like heavily censored.
Yeah, it was like today he went to eat at this restaurant. Like that's all the news we talked about. The food never down.
Okay. So for those of you watching at home, Latifa's from Kenya, where a few presidents ago, all of the stories about like, you know, government officials were very censored, very like positive, controlled by media. Now it's different where people are allowed to complain on like social media and stuff like that. So it's a very interesting, different standard. So again, the Supreme Court's looking at this case. They're not necessarily looking at like, was the ad mean, you know, this poor guy. Instead, they're like, look, dude, you are an elected public official. You are the commissioner of public affairs. People should be allowed to criticize and comment on your performance. So what they did was create this other standard that applies to two groups: public officials, so like government elected people, and the second group are public figures. So what is a public figure? Someone who's famous. Someone who lives their life out in the public. So if a government official feels that they have been defamed, they have to prove this extra element when they go to court, and that is actual malice. So actual malice, I want you to think about as being intentional, that newspaper published this story knowing it was false. They knew it was false, and they published it anyway. That's pretty messed up. Okay? Or maybe the newspaper didn't fact check or didn't do its due diligence and was grossly negligent in its publication. So again, the average person just has to prove that it was a false statement of material fact that caused harm, it identified the individual, and other people heard it, saw it, etc. But if you are a public figure, you have this extra element now because of this case where you have to prove that the other party, the defendant, acted like intentionally to damage you, or that they were so reckless that they completely disregarded whether or not it was true or false. Okay? Give your hand up.
I wanted to know one of like the headlines that I have to be able.
Yeah, let me walk the mic over to you. No pressure. It's just going on YouTube. Okay, just talk loud enough.
So,
What's your headline?
well, it's not necessarily a headline. It's about this soccer player who's like, in the UK, the media absolutely hate him and everything he does, they talk about it in a negative light.
Okay.
And he got a tattoo of a gun on his leg, and the media like went all nuts, like, oh my God, this guy, look at him, he's part of a gang and stuff like that. And he went on Instagram and he was like, when he was 2, his father had died from being gunned down, and he got the tattoo to remind himself like of what happened and to promise himself to never touch a gun and stuff like that. And then Kai Ford tweeted the post he did on Instagram, but he said they like added again into the phrase. They said he'd never touch a gun again, but he had never put it in his statement. Can he, if he wanted to, could he have sued them or?
Okay, so let's open it up for analysis and discussion with the class. That's a great article to find. So you have a famous soccer player who got a tattoo, got a lot of heat from the media about this tattoo because it had a gun on it. He goes on Instagram or Twitter and says, I got the tattoo because my father was gunned down and I will never touch a gun, period. Now you have a news outlet retweeting or reposting, and they doctor the statement and add again to it. So, false statement of material fact that causes harm. Like, what harm could happen to this guy because of that statement? He might lose his soccer contract, or maybe, he gets kicked off the team because they think he's violent, they think he's in a gang, etc. It clearly was published. It clearly identifies, him. My only question would be, is it defamation, or would it be something like, I don't know if it'd be an invasion of privacy, but it's almost like, not necessarily a copyright issue, but it could be like a fair use issue or something, where they're using his stuff, but then they're altering it to a certain point. But from a defamation perspective, it does cause harm. It identifies him and it was published. So let's say, do you remember the guy's name? Okay, so let's say Raheem decides to sue Sky News. He's going to have to prove that news outlet acted with actual malice. So he's going to have to get a lawyer and start doing some discovery, asking questions and collecting data and information to prove, in his case, that news outlet knew it was false and published it anyway. Or they were so negligent in doing their fact checking and they published it anyway. So that's that extra hurdle. Okay. So think about any time you see, when you're at Publix in the checkout line and you see those tabloids and you see all of that stuff. Do those tabloids, are they really publishing things like with reckless disabandon for the truth? Right? Shouldn't they be sued left and right for defamation? Because I think a plaintiff surely could prove actual malice. For those of you studying journalism, when you publish an article, you have to fact check all of your sources. You double, triple check all of the numbers, right? It goes through review, like an editor that looks at it and like verifies that information's in there, right? You contacted your sources, right? You vetted them, all of this stuff, right? That's your due diligence that you're doing. But imagine you write, like, you're angry at Miguelitos and you sit down and you write this nasty article and you bypass all of that. You don't fact check, it doesn't go for review, it just gets thrown out there and it's published, okay? That would be an example of actual malice. So it's either intentional, right, that they know it's false and they're like, I don't care, we're gonna make money, or they're just so grossly negligent in verifying the information. Okay, that rises that level. Now, the problem with all of this is who proves this in court? Let's take that example, does the soccer player have to prove it, or does the news outlet have to prove these elements? Who sues for defamation? The injured party, right? The celebrity, or the business, or the person that's harmed. They're the ones that has to sue. The person or entity that publishes the statement has to defend against a defamation suit. So, what makes this so hard to prove? If you're an injured party, especially if you're a famous injured party, how do you know if they acted with actual malice? Because you might not have right away access to that information. You can gradually gain information through what I said was discovery, like depositions, record requests, stuff like that, but that takes time. So it's difficult. And it's difficult to prove that harm, because as Jake said, it's nice and easy when a business loses money, right? Because you can put a price tag on that. But if it's someone's reputation, how do you measure damage to someone's reputation? Makes it a lot harder. So the New York Times versus Sullivan, really, really important to know about, because it puts into law that we treat public figures and public officials different than the average Joe. So those are the elements of defamation. Let's go into a little more detail about libel and slander, and then we're going to talk about the different types of libel that exist, and you're going to sound super, super smart when you go to your other classes. Really quick, before I move into that, when we talk about the publication part, does the size of the audience matter? You know there has to be at least one person, right? There has to be someone that receives it. But can there be a lot of damage if it's only heard by one person? Right? Depending on who that person is in the statement, yes. So it doesn't have to be broadcast to a lot of people. So size doesn't matter in defamation. Does that make sense? So even if just one person hears it, that's enough to prove defamation. Jake, slander is verbal spoken. Just keep in mind, slander spoken, SS, slander spoken. Libel is written. Always think about that. Slander spoken, slander spoken. Libel is written. Back in the day, back in like ancient times, because defamation laws existed even in like ancient Greece, all the way through like the formation of England, all that good stuff. And you know, we get a lot of our legal roots from England. We've talked about that. Back in the olden days, did people view libel or slander as being worse? Which one was worse? What do you think? Use your common sense. Hearing something spoken once, or the possibility of something being read over and over again? Being read. So libel was a much more serious offense. Now, libel and slander laws are not federal laws, they are state. So defamation and laws about libel and laws about slander will be different from state to state. And if you were paying very close attention to that video, you would have heard the news reporter saying that a federal jury ruled on the 1.8 million. If anyone knows the answer to this question, I will give you 5 extra points on your midterm. This does not apply to the online people because you could probably Google it, like when you're watching from home. Does anyone know why that defamation case was decided in federal court? No one knows? All right, take a guess. 5 extra credit points. Okay, that would be close. Okay. There is an exception for a state case to go to federal court. And that is if you've got two people that live in two different states and you have an amount in question, like that, say Jesse Ventura is asking for a certain amount of money, it has to be over $75,000. So if that happens, then the plaintiff or the defendant can ask that the case get bumped into the federal court system, right? It's all part of the strategy of making sure you pick the right court. So close, no cigar though. So again, it was a federal matter. A federal jury decided because you have two people living in two different states and one of them is suing another, asking for over $75,000. So at some point along the legal battle, one of them asked the case to be removed to federal court. But in Florida, you have certain statutes that explain Florida's defamation laws. And I actually pulled up a couple of them that we can talk about in a second. So historically, libel would have been things printed in newspapers, books, pamphlets, leaflets, etc. Spoken would have been the person standing in the town square saying, "She's a witch," you know, that kind of stuff, spoken. But then fast forward several hundred years and we get to the era of radio and TV. Where does radio and TV fall on the spectrum? Is it slander or is it libel? If I'm a radio host and I start talking trash about someone and I'm spewing all this fake information, is it slander or is it libel? What does your gut tell you? Your gut says it's slander because it's spoken. What about if I am a news anchor on TV, which a number of students enrolled in this class want to be, like news anchors on TV, and they say something on air that's being broadcast that's a false statement of fact that causes harm? Is that libel or slander? What does your gut say? You're on TV and you say it. Your gut says it's slander, but as she says, once it's out there, it's out there. With radio and TV broadcasting, the answer is it depends. It depends what state you're in. A lot of states and jurisdictions, and the American Law Institute, which is a secondary legal source, has issued statements saying radio and television broadcasts are considered libel. So it goes against your gut. Your gut says it's spoken, but in reality, it could be considered libel because most of those things get recorded. When you broadcast a TV, like a news show, you can probably go onto YouTube an hour later and pull up that news story. Same thing with radio, is it could be like copied and filed away. So one reason is that it's recorded, so it memorializes it in a way that like other written stuff memorializes the information. Another argument is it should be libel because of the reach of that statement. Because radios and news, like things on TV, have a huge audience base. So because of that and because of the size of the audience, then they say it should reach libel because libel has always been viewed as more serious. But that's something that when you enter into the field, you're going to need to look up. How does your state treat broadcast defamation? Is it libel or is it slander? Because you have a national entity, organization saying that it's libel, but that's not law, right? That's just an organization making recommendations. So you need to look at your own state laws to see what they are. So I looked at Florida statutes. Ironically, I've never looked before. And there's a bunch of different statutes regarding libel. So if you go onto the Florida statutes, it's under chapter 770, and that is the torts chapter. Sorry, it's under the title of the whole big section is torts, and it's chapter 770, and that's civil actions for libel. So what's interesting about it is if you Google Florida Statute 770.01, it says that before any civil action is brought for publication or broadcast in a newspaper, periodical, or other medium, that the plaintiff shall, 5 days before instituting the action, they have to serve writing and notice to the defendant. So let's say the Tampa Bay Times is publishing an article about me, and I think it's defamatory. Before I file a lawsuit against them, I have to give them notice 5 days in advance so that they know, right, that that action is coming. Under section 770.02, this is really interesting. A newspaper, an article, or a broadcast, if it's published in good faith, so like none of that actual malice stuff, if they genuinely thought it was a real thing, they have to issue a statement, like apologizing for the error and correcting it. So have you guys ever seen a news outlet like correct itself or issue a retraction? They have to do that. And if they do that, then the plaintiff can only recover like the damages that like the loss of the income. They have to prove that, but that's all that they're entitled to. And that apology has to be within a certain window. So if it's a daily or weekly newspaper, podcast, or periodical, they have to apologize publicly within 10 days. If it's a newspaper or periodical that's published semi-monthly, then they have 20 days. If it's a once a month newspaper or periodical, then they have 45 days, like a month and a half to retract. So again, depending on the type of outlet, then the window to apologize changes. And I thought that was pretty interesting as well. So again, if you ever go into broadcasting or journalism, you're going to need to know about this. You're going to need to know that before you're sued, the plaintiff has to tell you in writing where your mistake was. And then if it was an accidental mistake, you have to protect yourself by not opening up yourself to like giving them more money by apologizing, and you have to do it within a certain window. So I thought that was pretty interesting information. So if you want to play around, like if you think you are going into this field, like I know Sam, I think, wants to go into this field, you might want to spend some time tooling around for statutes, right, in that 770, right, 770 section that you can learn about it. Okay, so we've got some confusing stuff going on with radio and broadcasting, but we're going to talk right now more about libel because that's a bigger, more serious issue. So there are 3 types of libel that I want you to be aware of. They're mentioned in your textbook, but I want to make sure that you have a clear understanding of it, because I do know that the textbook can be a little convoluted at times, to put it mildly. So first, there's a concept called libel per se. 2 separate words, per se. Libel per se means that there is libel on its face. There's defamation. You look at that statement and you know it's defamatory, right? It's a statement that's libelous, flat out on its face. There's 4 categories of libel per se that if you hear or read this statement, you know that it could be defamation. First, accusing someone of a crime. So again, I get the minaret involved and they publish a story about Dr. Gurry stealing laptops. It's a false statement, right? And we're accusing him of committing a criminal activity. Just looking at that, the minaret could be liable for defamation because of the type of statement. What else do you guys think is bad enough that it would rise to the level of defamation just from looking at a statement? What kind of things do you think people think like, oh my God, that's so bad? Like what could the minaret publish that you'd be like, oh, that's defamation? Crimes, what other bad things? What if I say, that was him stomping upstairs, by the way. Isn't that scary that I recognize my colleague's footsteps? Like boom, 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 boom. Always him. What if I say he has herpes? Do you think that's pretty bad? Okay. The second type of libel per se is you say someone has a contagious illness. So again, the minaret could publish and say, Dr. Gurry has COVID-19, and he's spread it to all of his classes, 60 students. It's completely untrue, but just on its face, right, he doesn't have to prove anything because that statement is so bad. This dates back to olden days, and that's sexual immorality. And when Sam goes and starts digging in the Florida statutes, this is still on the books in Florida as well. So this is back when, people weren't as liberal as they are now about sexuality. So if you were like, she's a whore, or, like in the 1800s or 1700s, like guys only would marry a virgin, right? Someone that's pure. And then if you're like, she ain't no virgin, right? And it causes them to not get married. So like statements about someone's sexual activity, like sleeping around. And then the last one, which you're probably most familiar with, is you attack someone's reputation in their business, trade, or profession. So maybe the minaret publishes that he's a lazy professor that sleeps with students. That's attacking his reputation in his profession, and that's going to damage his reputation. So again, these are statements that are defamatory on their face because they involve such serious things. You don't really have to go around and pull outside information to make the case that it is defamation. Opposite of that is something called libel per quad. You gotta love the legal profession stealing all this stuff from Latin. I've never took Latin in like high school or anything, so I never know what any of it means. But libel per quad means the statement might not be defamatory, but when you look at the context of where it was spoken or published, it then becomes defamatory. So an example would be if I say, Dr. Gurry is healthy. That's not defamatory, right? That's not a bad statement. He's healthy. But what if he's filed all of these false claims with his insurance company, saying that he's ill so he can get all this money and like swindle them? So now when you look at that statement, right, it could be considered defamation because of the context that it's in. So for this, you need outside information to prove the context. These, you look at the statement and you're like, oh my God, that's bad. With libel per quad, you're like, it might not be a bad statement, but when you step back and look at the whole picture, then yeah, that's a bad statement. Does that make sense to everybody? Okay, my last one is my favorite, especially for those of you involved in like Greek life, because I always like to pick on like sororities and fraternities for this. It's called group libel. That could be defamation that's out there to destroy the good name of a group, not just a single person. So I hesitate to bring this up, but I do know that over the summer, the college Democrats and the college Republicans, are anyone members of that, of either of those? So like the college Republicans posted something on their Instagram, and maybe like the Dems like called them out or reported it or something, but the post got taken down and they were like, I think something happened with like the bigger chapter or something like that. But let's say they have a rivalry and the UT Republicans are posting things, right? And they're targeting the UT Democrats, that organization. Or maybe the UT Democrats start putting things on their Instagram, trash talking the UT Republicans. that could be defamation. Those organizations could, right, sue each other for defamation. It doesn't have to be an individual person. So maybe you have some rival sororities or rival fraternities because you guys have some that you're like, oh, I don't like. Like, I know I've heard of certain sororities that get like bad reputations on campus. You guys know what I'm talking about, right? Like, you're in a sorority, right? I see your stickers. Oh, okay. When you were in yours, was there like another one that you were like, no one liked? Or like, oh, the scrubs joined that one? Kind of, yeah. So imagine that organization goes on this campaign to trash talk the other sorority. That other sorority might have grounds for a defamation suit. So even though it doesn't identify individual names, right, but it could target the group. It has to be a small group though, right? It can't be like a whole campus that's being defamed because that's going to be pretty difficult because there still has to be that element of identification. You have to be able to identify the organization or something like that. So I think those are pretty interesting, right? Some statements are so bad that they're just defamatory on their face. Some you have to look at the context of how it's said, and others would be group. So there's a second communication major. You know, there's 2 communication majors now. There's communication, media, and culture, and then there's communication and speech studies. What if the communication and speech studies goes on this like blast, like on our Instagram, saying that if you get the CMC major, you're never going to get a job, they're terrible, blah, 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 all this stuff. That other entity could absolutely sue us for defamation, right? And it would be group libel because it's not just one person, it's an entity. Make sense? Okay, so moving down, let's talk about defenses. If you're taking notes, you will want to label 1 through 10 because there are a lot of defenses. Some are noted in your book, some are not noted in your textbook. So here we go. You work at a newspaper and you publish something about the mayor of the city where you're living. You get sued for defamation. What can you say to protect yourself and your newspaper? If you're a journalist, you're going to waive what right? Yes? The First Amendment. Very good, Jakob. That is Jake in some other language. Okay. All right. So first, you can say, it was my First Amendment right to say that. It was my First Amendment right to publish that. Sounds nice and fluffy. Courts may agree with you, but might not. So what are some other arguments you'd have in your back pocket? So remember, this is a plaintiff is suing a defendant. The plaintiff is the injured party. The defendant is the person or entity that published the statement. What a defense is, when the plaintiff sues the defendant in court, the defendant raises a defense, and it's like a shield, right? It protects them from liability. If we know defamation involves a false statement, what do you think the opposite of that would be? A defense. If I own a newspaper and I run an article, and the subject of the article says that's fake, that's false, what can I come back and say? Actually, it's true. If the statement is true, there is no defamation. For those of you that want to go into the news, you need to make sure what you publish is true. Because if you get hit with a defamation suit, you just pull that truth out of your back pocket and you win. If the Daily Mail had evidence that Melania Trump was actually a hooker, it would win. Because it's a true statement. You guys know that expression, the truth will set you free. In defamation cases, Absolutely. What else? What else might be a defense? I am interpreting silence that you guys are not reading before coming to class, which is very bad news. So let's make sure that we do that moving forward. Anyone else want to take a guess? Yep. No, that's the First Amendment.
Okay.
So shield laws, it kind of overlaps with privilege. So let's hold on to that thought. First, if you know that defamation has these like three main elements, right? The false statement, published, and it identifies a person, your defense can be that there's something missing, that there's an element missing, so that there's no identification, or that it was never published, or it was never seen by anyone, right? You poke holes in that, they're evidence altogether. Make sense? So someone could sue the newspaper and say that was defamatory, but I'm going to be like, well, we never ran that article. That was never published. Or we ran that article, but it doesn't identify you. There's nothing in the article that anyone would be able to figure out, right, what you're doing. If, let's say we pick on a sorority, the Minaret publishes an article saying a sorority on campus is full of prostitutes, and they name that organization. That sorority sues the Minaret for group libel. The Minaret might be able to use as a defense, well, your reputation was already so bad that us calling you prostitutes or whores does no damage. That's something that's called tarnished reputation. Or your book calls it libel proof. I don't like picking on Greek life because I think there's a lot of good that comes out of Greek life, but they're good for group libel. So let's pick on Miguelitos again. I published this article saying that Miguelitos is awful, but guess what? Miguelitos has a 1-star rating on Yelp. Their reputation is already really low. So me publishing that, it's not really damaging them any further. Does that make sense? So it's like someone already has a bad reputation. So for example, I saw on the news that there was a dentist that was removing a tooth on a patient. I don't know if you guys saw this. I was on CNN. And he was filming the whole thing, but guess what he was doing at the same time as pulling this patient's tooth? He was standing on a hoverboard, like one of those like skateboard things, next to the person in the chair, and he's pulling the tooth while he's on that thing. Okay, so he's going to jail, by the way, for like lots of other stuff that he did that was bad. So I run a story saying that guy is a bad dentist, like generically. Is that going to damage his reputation? Of course not. That guy is like done. Right? His reputation is so tarnished that in a way, he's now become libel proof. Okay, so think about that. When we talk about reporting, you might be able to argue and say, I was reporting something neutral, right? I was neutral reporting. I was simply reporting the facts. It was not my intention, right, to do something negative. Also, with reporting, you might be able to show that it was responsible reporting. So if a celebrity sues your newspaper for defamation, and they're trying to prove that actual malice, right, that you were so reckless, you might be able to pull up and say, look at all of the steps that I've made to verify this information. I contacted this source, we fact checked this, it went through our editorial review board, we did our due diligence, etc. We were responsible. Okay, so that's a pass. Word is terrible, so I don't even know if online people can read this. There's something called the wire service defense. So those of you studying communication, journalism, probably even ad PR, you realize that most of our media, there's big media conglomerates, right? And we have like the AP wire and Reuters and all that stuff. They might issue a story that trickles down, and the local news outlet picks up a story, like a national story, and they report it and they publish it. If that initial story was wrong, you can't turn around and sue the little guy because they got that information from what they thought was a reputable news source. So that's a form of protection as well. So again, you're on the Minaret, right? So the Minaret sees a story in the Tampa Bay Times, and they decide to take that information and publish it. They're republishing something that they got from another news outlet because they thought it was true. If it turns out that it's false, we're not going to be able to sue the Minaret because they believed it was true because it came from a reputable news source. That makes sense. So if you get information from the big dog and it's false, the little guy can raise this as a defense to protect himself. So I figured you guys would probably like that. 7, 8. Privilege. This might be kind of related to shield laws, but shield laws are more about like you don't have to reveal your sources and stuff like that. So kind of, there's 3 types of privilege. Your textbook only mentions one of these. So I want to make sure that you guys know fully all of the different types of privilege. The first type is something called absolute. And an absolute privilege is a type of privilege that is created by law when, for example, 2 people get married. If Jake and Matt marry each other because same-sex marriage is legal, Jake kills someone and he tells his husband, oh my God, I murdered this person. Can Matt be forced to testify against his husband in the court of law? No, there is a marital privilege. So what one spouse tells another one, right? If you're married, it has to be marriage. You can't be forced to testify against that person in court. It's designed to help trust in relationships and protect the sanctity of marriage or some bullshit like that. Another example of an absolute privilege would be attorney-client. So if I'm representing a client and they tell me something, I'm not allowed to break that confidence, that confidentiality. So again, someone could defame someone when we're talking in my office, but I can't be compelled to testify against that person. Make sense? So there are certain legal privileges that exist about communication. So you can defame someone to your husband and then not be sued, or if you're sued for defamation, your husband doesn't have to testify against you. Make sense? The next type of privilege is called a qualified privilege. So again, there's some immunity, but it's not complete. So for example, are there food critics in Tampa Bay or in any city? What if a food critic goes to Miguelitos and is just as disappointed in their bottomless mimosas and in the ice cold quality of their food? I'm telling you, I had a really bad experience, but if Kayla thinks I need to go again and try it, I would consider it. Go during happy hour? Okay, that's noted. If a food critic publishes an article, like in the food culture section of the newspaper, can they be sued for defamation when they're just doing their job? It's the same thing with like an art critic. People get paid to go in and give their opinions on that, or books, literary critics. They're not defaming the artist or the author or the restaurant. They're simply stating their opinion. That's part of their job. So professional reviewers can raise this as a defense if they're ever sued for defamation. So again, if Miguelitos gets mad and goes after that food critic, the food critic can say, I have a qualified privilege because I'm a food critic. The last one is something called fair report. This is mentioned in your textbook, the fair report privilege. So again, if you are a government official speaking about your official duties, you cannot be sued for defamation. Again, if this is a government person talking about information related to their job or their official duties, then they're going to be immune to defamation. Because we want our government officials to feel free to tell us information, even if they think it's not good information. Nine is called letters to the editor. So again, if there is a story that is published and all of the people in society get upset and they start writing in their comments and opinions to the editor, their letters to the editor are not defamation. Because again, some news outlets want to encourage feedback from the community. So if someone's unhappy, right, with my article about Miguelitos, they should feel free to comment on that without fear of me turning around and suing them. And the last one that I think will spark your attention relates to internet service providers, ISPs. What's that pesky little website where you guys go and you bitch about your professors and it can be completely fake and false information that can be really hurtful about your professor? Bingo, rate my professor. I don't know if it's UT students, but students in general, y'all are vicious as fuck. I read a review on one of the, like, I think she was in management at UT, and they're like, no wonder she's a bad professor. No wonder her husband is divorcing her because she's a terrible human. Like, they went for, like, the jugular on this. Like, they did not like this person. So say homegirl, right, loses her job because of that post on Rate My Professor. She wants to sue Rate My Professor for letting that be published. Can she sue Rate My Professor? Nope. Internet service providers and things like Yelp, Rate My Professor's websites that let you review other things, the websites themselves are immune. She might be able to go after Rate My Professor and ask them to give the user information, but as you guys know, it's all anonymous, right? So I'm sure Rate My probably has like the IP addresses for all of the people that posted and stuff. But really, Rate My Professor is at no risk because they're not the ones commenting, they're just providing the platform. Similar to Yelp. So feel free to review your hearts out on Amazon and Yelp. Well, maybe not, because Amazon and Yelp can't get sued. But if they find out that it's you and you cause damage, that might be another story. Okay? But this protects those platforms. Questions? So again, the injured party has to go through and prove all of these different elements, and there's different types of defamation. And the party that's being accused of having published the defamatory comment has at least 10, but I'm sure there's more, different defenses, shields they can throw up that will mean that they will win the case and that they might not have to pay out. Okay, does that make sense? All right. We don't have enough time. I was going to go into the damages, but the way that you calculate how much money someone gets is you can look at the actual like damage to their business or lost income, and that's called an actual damage. So you can actually put a price tag on that amount. But then there's other things like general damages where I might ask for money because it's just hurt my reputation. But again, you can't really put, there's not a receipt or a price tag on someone's reputation. So there's those two types. One is like the actual things where you can lay a stack of receipts and bills and spreadsheets saying I've lost this much money. You might be able to recover some general damages for just hurting your reputation. And this is a good one. If the defamation is really extreme, then the injured party might ask for punitive damages. Do you guys know what punitive means? It's like punishment damages. So if a newspaper publishes something with actual malice, let's say they know that it's not true, then it's possible the injured party can ask for like these punitive punishment damages and collect even more money. But of the three, the easiest one for you to get is you pull up, like, here's the job I lost. Here's the lost revenue to my business, right? Those type of things you can put a price tag on. The next one is harder, damage to your reputation. But if it's bad enough, you can ask the court to go above and beyond both of those and punish that individual. And so again, you'd probably do that for someone with like deep pockets or something like that. Okay, so we have no questions about defamation. As you go forward and watch the news, or you're on social media, you're looking at Twitter, Instagram, if you see something about someone's sex life or their professional reputation, or that accuses someone of a crime, or it's just something that's negative about someone or a business, you might want to think, does it meet the criteria for defamation? And you can go through that whole analysis. And in fact, that might be, is that what you guys are doing on the discussion board? You guys don't have it. Nope, we're going to learn about advertising. Never mind. So hopefully you guys will know now to be very careful with what you put out there. Even on social media. Social media can get you in trouble too. Tweets can get you in trouble. So your homework is, I wanted to be very clear. This week you're going to be learning about regulating advertising, which a lot of your essays relate to advertising. I'm about halfway through with them. So probably by the end of the week, you'll have your grade and comments for me on your essays. So far, no one's gotten below like a 40 out of 50. So you guys are, you know, I'm only halfway through, so maybe the worst one for last. But anyway, when you do your online work, you're going to watch a lecture video and make sure you read the textbook. Your discussion board, I actually want you to find an example of an ad, like especially an old ad, and look for like some crazy fucked up shit. Like there's all kinds of like wild old ads out there. And then see if you think that ad would survive under modern day regulation. So learn about how we regulate advertising, and then see would that ad actually be allowed to be printed in 2020. Then your homework over the weekend is to take the case that you selected and do a brief. And I've already talked about the requirements for that. It should be no longer than 2 pages in length. Typed, right? Make sure you have the categories clearly marked. Be very concise. And take a look at your case this week. Some of them are long. Some of them are confusing. So if you are lost when you look at your case, reach out to me, and I'm happy to meet with you to help. Okay? But don't wait until Sunday night or Sunday afternoon and then reach out. Be prepared to talk and do a mini presentation on your brief next. Got it? Good? Okay. Go out and be careful not to defame anyone accidentally.